I'm not going to use your name. I'm going to use your initials. These are posted on the, these arguments are posted publicly. So NC, the next case, or is NS, excuse me, on behalf of a minor child versus SA. There's only the appellant here to argue, so you'll have 15 minutes to present your argument. Please introduce yourself. Actually, don't introduce yourself, just say your initials. Keep your voice up and remain behind the podium. You should also not use the names of children, minors, and victims during your argument, and you can refer to them by initials or terms like the child. We have read your brief and are ready to proceed when you are.
May it please the court, I am NS, appearing pro se on behalf of my son, minor child. He was physically harmed in the hands of SA. He was dragged down the stairs and burned. He was left to suffer without medical attention. These instances have occurred throughout 2025, as well as other instances that have occurred in prior years. In this case, they put everything right back to the judge who had determined the custody case. As they said that there was jurisdiction there, even though it was not about the other parent. The child has suffered mental, physical, and emotional harm, and is begging not to return over to that house. There were 3 assignments of error that I presented in my brief. The finding of insufficient evidence of domestic violence against the manifest weight of the evidence. The magistrate wanted corroboration of the incidents that happened that were listed in the DBCPO, and when there are only 2 people there, you are never going to get corroborating statements. One person is always going to say that it didn't happen, the other person is always going to say it did. In this case, there's actual physical harm that proved that these incidents did occur. In the April incident, the child was drugged down the stairs because he asked to use the restroom. And SA did not feel like removing her children from the shared upstairs restroom so that he could go. Instead, she decided to pull him down the stairs, to which she can't remember if it was gently or not. She claimed that there were no bruises, although her attorney, Michael Wilson, had stated and confirmed that there were bruises from that incident. Which leads you to question whether or not SA was actually telling the truth. The magistrate believed her account of the events over evidence that was allowed to be presented, as well as over the testimony of the minor child who suffered at the hands of her. Then on August 4th, the minor child was burned by SA. She did not seek medical attention for him. She did not console him when he was crying. She did not tell me about it. When I picked my child up, I was immediately told by him, and went directly to Amherst Police Department asking them for help. They looked at it, they called Life Care immediately, and the ambulance showed up and transported my son to Mercy Hospital. Later, a sheriff's deputy arrived to speak with me and investigate. He did not report anything to CPS. He thought the hospital was going to do it and did not realize that that was part of his job. He was I'm not sure exactly what they called it, but he had something put on his record, according to the detective, about the incident and him not reporting it. And then training was also ordered for him as well. This is not a 1 or 2 10 thing. This is an ongoing issue where we can't get any help from the courts or from police or anybody because of the parties involved in this case. Attorney Wilson used a 2020 transcript from a newly 4-year-old child who was only having a conversation with me while laying in bed before going to sleep and asking me questions like normal parents, have conversations with their children. I was trying to understand what he was talking about, if he was telling me something that had actually happened, or if he was telling me something that he had maybe seen on TV or YouTube or whatever the case may be. I was trying to understand exactly what he was talking about. And that transcript has been used against me since 2020. It has been used repeatedly, even though it is not supposed to be used repeatedly under the doctrine of res judicata and collateral estoppel. It has been ruled upon multiple times in the custody case. It seems that every time there's something that SA cannot give factual answers to, that they pull out the transcript to deflect the actions and try to blame myself or the child for whatever has transpired. Magistrate Oliver clearly said in the hearing, which is in the transcript, that he would only allow the transcript to be used for impeachment purposes only, and not for consideration for the DCPO. And the impeachment purposes were supposed to be towards me as Attorney Wilson has stated multiple times on the record. I was never given any notice about the transcript being presented. The child was never questioned about the transcript, even though the child did testify, stating that he was scared of SA and did not want to go back over there at all. But the magistrate subsequently just denied it, claiming that he was not credible. This seems to be a bigger issue throughout the United States that I didn't know existed until maybe the past 6 to 12 months, where family court is handing children over to the abusers, the people that harm them. Arizona has just initiated an ad hoc committee meeting to help bring this issue to light. Other states are jumping on board. I'm petitioning Ohio to jump on board as well, because that is also happening here. I'm asking that this court reverses the DCPO and puts it back into place so that my child has some sense of safety, and so that I do as well. He's terrified all the time to go over there, cries, screams. He wouldn't even go trick-or-treating because he was so afraid. These issues have taken over our entire lives, and all we're asking for is a proper investigation by people that are not biased and that don't know the other parties involved. If police officers are going to be doing an investigation, it needs to be somebody outside of the jurisdiction. Same with the courts. I would urge you to make a determination as quickly as possible. To help us. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk will mail you a copy of the decision on the